Good afternoon, everyone. Welcome to the show, The Politically Social, and I'm your host, Afia. Today we have with us Staff Judge Advocate for the Air Force Materiel Command, Colonel Eric Mejia. He received his undergrad degree from Arkansas State University and his JD from University of Arkansas. He served in a number of roles as an Air Force attorney, including as an area defense counsel. Currently, as the senior military attorney for a major Air Force headquarters, Colonel Mejia leads a team of over 460 attorneys and paralegals at 18 legal offices. His team provides legal support to the command staff for an organization of 89,000 personnel who manage about $60 billion annually in research, development, test, and evaluation, as well as oversee the acquisition, modernization, and sustainment of weapon systems for the U.S. Air Force. Our topic today is Major General William Cooley's conviction. Major General William Cooley was relieved of command of the Air Force Research Lab and later court-martialed. Welcome, Colonel Mejia.
Thank you very much, Afia. Thank you for the introduction, and thank you for having me here. If I could, just to provide a little bit of background about the case that we're going to discuss.
Sure.
So, as you correctly noted, General Cooley was a major general. That's a two-star general in the Air Force, and he was one of the commanders of AFRL within the command that I'm the staff judge advocate for, which is AFMC, or Air Force Materiel Command. About 2019. His sister-in-law came forward to our investigative agency, the Air Force Office of Special Investigations, and made an allegation that her brother-in-law, General Cooley, had sexually assaulted her after a party. So as you know, that was investigated, and then as a result of that investigation, 3 criminal charges were brought against him. And those 3 criminal charges were, 1, him forcibly touching her, and number 2, making her forcibly touch him, and then number 3, what it was essentially a forcible French kiss, for lack of a better word, him inserting his tongue in her mouth without her consent. After the charges were brought against him, he was tried in a court-martial by Judge Cristina Jimenez, also an Air Force JAG, but a specialist as a military judge. And he was found guilty of 1 of the 3 charges, that being the forcible kiss. And then he was sentenced to forfeit over $50,000 worth of his pay and to also be reprimanded. And the case is significant, and I understand why you're talking about it, is because it's the first time in the Air Force's 75-year history that a general officer, has been prosecuted and convicted in a court-martial.
Right. So my first question about that is, General Cooley was convicted, but he could not avoid prison and was not dishonorably discharged. What message does this convey?
Right. So I think this is it's a nuanced question, right? So first off, it's important to understand that General Cooley was not necessarily prosecuted to send a message. He was prosecuted for the actions that he took on that day against his sister-in-law. But definitely, people take messages from courts. They have a public impact. And one of the things that I've noticed of this particular case is it's kind of a polarizing case, and people tend to fall into 2 different camps or 2 different categories. There's the camp that view the military and say things like, well, it's different spanks for different ranks, and the higher up in rank you go, the less like you are to be held accountable and to be punished. And this is an example of that, because he was only found guilty and lost some money and a reprimand. So this just proves different spanks for different ranks. And then there's the other category, the other camp that says, well, this is the Air Force bowing to public pressure, and that's the only reason he was prosecuted, and this was just a forcible kiss, and he's going to lose his career over that. And I would say that there's a message to each of those 2 camps, right? So the first folks who think different spanks for different ranks, I think this case clearly demonstrates that regardless of your rank, if the Air Force, if the military finds out about credible allegations of misconduct, especially sexual misconduct, we're going to hold you accountable, and we're going to take you to court if that's appropriate. And it doesn't really matter how many stars you might have on your shoulder or whether you have no stars on your shoulder. It's the conduct and the disorder to good order and discipline that you're going to be held accountable for. To the other side that says, well, this was just an example of the Air Force bowing to public pressure and it was just a show or a spectacle or whatever. I think the mixed verdict, in other words, finding him guilty of one specification or one charge but not the other two, the message there is no, this case was decided on its individual merits, with the judge weighing each of the charges and deciding what he was guilty of by proof beyond a reasonable doubt, and those things that there was not proof beyond a reasonable doubt. It was certainly not a show trial. It was a serious application of the law by an experienced judge with results that back that up. So I think those are the two messages.
Right. So from a legal standpoint, how do you think the general avoided more severe penalties, including a dismissal or reduction in the rank, or even up to 7 years in prison?
Right, right. And as you correctly note there, the maximum punishment for the crime for which he was convicted, the maximum that the judge could have imposed would have been 7 years in jail or a dismissal to be kicked out of the service. I think the key to understanding why his punishment was a forfeiture of $50,000 and a reprimand is to understand that first off, of the three charges that were brought against him, the one he was convicted of was arguably the least egregious, right? It was a forcible kiss versus him forcibly touching her genitals or him forcing her to touch his genitals. Those would probably have been considered the more serious offenses than the forcible kiss. Now, I'm not in any way, shape, or form suggesting that what he was convicted of was trivial or light or unimportant in any sense of the word, right? What he did violated her privacy, violated her sanctity in her body, and was wholly and completely unacceptable. But on the spectrum from rape, right, forcible penetration, to this was of a less egregious nature. And so I think the fact that he was found only guilty of one of the three offenses and of the conduct that was described in the one offense that he was found guilty of probably best explains why his punishment was what it was and why it was not, 7 years in jail or to be completely kicked out of the service.
Right. And as you mentioned before, this is the first court-martial of a general in the branch's 75-year history. But recently, we've heard a lot about Me Too in the military. What is your opinion on that?
So Me Too in the military and in society in general was a show of solidarity, or at least that's how I would characterize it, a show of solidarity among sexual assault victims. And I think it served an important function in society by heightening awareness of the problem of sexual assault and just how prevalent it was in society in general. So I think that is a good thing, right? Anytime society, including the military, which is a subset of society, can be made more aware of a problem that it's already aware of, but may be made more aware of it. I think that's good, and it causes the military and society to adjust their behaviors and their laws. The Uniform Code of Military Justice, which is the body of law that the military follows, and the military justice criminal procedure is a dynamic thing that was designed to and does in fact change with the times. And these sort of movements help society and the military adjust what they do to better serve the needs of society, and in this particular case, to better serve the needs of sexual assault victims. So I think on the whole, it's a good thing.
Right. Colonel Matthew Neals said recently that if this result influenced just one survivor to know that his or her attacker's rank or status would not prevent them from being held accountable, that's a win for the U.S. and the entire military justice systems. Do you share those beliefs?
Yes, I absolutely do. And so just for orientation, right, Colonel Neil Matthew was Colonel Matthew Neal the prosecutor that was in court that actually did the hands-on prosecution of this case. I as the staff judge advocate of AFMC, my job was to advise our four-star general, General Arnold Bunch, who was the one who decided, on advice to send it to court and to seek a prosecution as opposed to some other disposition. I agree with his statement. I think we all know that it is very difficult for sexual assault victims to come forward and to disclose what happened to them. Right it's something that tends to happen just between two individuals, and sexual assault victims look at various justice systems and prosecution systems, and they draw conclusions about how they're going to be treated. They draw conclusions about whether anybody is going to believe them or not. When you're dealing with powerful individuals, and there's no doubt that a two-star general is a powerful individual within our military system, they look to see if they really are sort of immune from their own misconduct and the consequences of it. So I think this case sends a message that they can come forward, they can share their stories with us. We will take it seriously. If the facts and evidence support it, it doesn't really matter to us whether the person's got 4 stars or no stars. We will hold them accountable for their misconduct. And so I think you hit the nail on the head with that statement.
Right. Now, General Cooley, as we discussed before, was charged with 3 specifications, but convicted of only 1, which is forcibly kissing his sister-in-law. Right. He was not convicted of pushing her against the car door or inappropriately touching her. What do you think were the legal grounds for not being convicted of those 2 charges? Because as per the prosecutors, there were written admissions of guilt.
Sure. So I have to caveat that first by saying that I was not actually in the courtroom. I'm kind of from my position, I tend to be behind the scenes. So I didn't see that play out word for word in court. But I mean, from experience, and you being an attorney know this as well, of course, is that a judge looking at charges will take the 3 different charges in this case individually and try to assess whether there is proof beyond a reasonable doubt, because that is our criminal standard, which is a very high standard burden of proof. And sexual assault cases are really kind of unique because they normally happen in private. It's normally only going to be 2 individuals there, right? The perpetrator and the victim, and it's going to be the perpetrator's word against the victim's word. And so then you kind of have to go on a search for other things that may corroborate the statements of each of them as to each charge. So I suspect in this particular case, that the judge found sufficient corroboration or sufficient indications of proof beyond a reasonable doubt as to the 1 charge of forcible kissing, but the proof did not come up to that level for the other 2. Which is not to say that it either it did or did not happen. It's to say that there was not proof beyond a reasonable doubt to establish that. There must have been a reasonable doubt in the judge's mind as to those 2 other charges, but 0 doubt in her mind as to the one for which he was convicted. And that's true not in this case, but in many cases you wind up with the result of a mixed verdict, guilty of some things, not guilty of other things.
Right. The victim said that the price for peace in my extended family was my silence, and that was too high a price to pay. Now, this is a sad reality. We've seen that victims don't open up. And then we've also witnessed cases like that of Vanessa Gullen. As a judge advocate in the military, what is your take on this?
So I think your assessment is your characterization of it as a sad reality is spot on, and especially in this case, right? This case even had the family dynamic aspect of it that not all cases necessarily have. So in her particular case, she was sexually assaulted by her husband's brother. So for her to have kept silence just to keep peace in the family, if you will, I can see how she would have determined that is far too high of a price to pay. And we think that she did exactly the right thing, right? She shouldn't have to pay any price. There's no price that she should pay. She's the victim. She's not the one who has to pay the price. It's the perpetrator that has to pay the price. So her coming forward and telling her story, allowing the Air Force to investigate, cooperating throughout this process, which was about a 2-year process, right? Because of COVID tended to slow things down. I think showed a lot of bravery, and I think it does send a message and set an example for other victims that the military will take their cases seriously. We will investigate it, and we will hold perpetrators accountable for their wrongdoing. They don't need to pay a price. We try to make every effort to encourage them to come forward. To make the perpetrator pay the price.
What does Article 120 of the Uniform Code of Military Justice exactly say?
Right. So as I alluded to earlier, right, we have what's called the Uniform Code of Military Justice, and it contains a listing, if you will, of criminal offenses that are both shared by the civilians, right? Murder, rape, sexual assault, the same things that are in the civilian sector we have in the military. And then it additionally has military specific crimes that there's no analog for in the civilian system. For example, in the military, it is a crime to not show up to work, right? That wouldn't be the case if you worked in the civilian sector, but because of what we do and it involving national defense and the criticality of what we do, you have to be at work. It's just, you can't compromise national security just because you choose not to come into work one day. So Article 120 of the Uniform Code of Military Justice is that portion of that body of criminal law that addresses rape, sexual assault, aggravated sexual assault, and abusive sexual contact. So the range of sexual crimes is contained there. And it also contains, as you've seen in laws, right, the definitions, what does each word mean? As well as the penalties for violating them, because there's a much higher penalty for rape than there is abusive sexual contact, and also contains some of the defenses that you would be familiar with as an attorney, like mistake of fact and things like that. So that's what Article 120 is. It encompasses sexual offenses for the military.
You said this case clearly demonstrates the commitment of Air Force leaders to fully investigate the facts and hold airmen of any rank accountable for their actions when they fail to uphold Air Force standards. Do you think General Cooley was held fully accountable, and has the Air Force really investigated the charges completely since, again, he was convicted of only one specification?
Right. So obviously we charged him with more than he was found guilty of, but also, right, as an attorney and a believer in the value of our system, I don't hold any animosity towards the way the results turned out. I believe he was held fully accountable, and the reason I say that is because to hold him fully accountable in my mind is to investigate it thoroughly, to make an informed and sound decision as to what he should be charged with, to make sure that he goes to court where a experienced and skilled military judge listens to all the evidence and then determines within our system, which requires proof beyond a reasonable doubt again, that he is guilty of something, and then to assess an appropriate sentence. So in my mind, to not be held accountable is to get away with it. To never even risk the consequences. But also in my mind, General Cooley was held fully accountable by the Air Force because he went through the entire process, again, only having been found guilty of one offense. But by the same token, I trust that military judge, who is a very experienced military judge, was able to weigh all of the evidence. And as you know, right, there's only a certain amount of evidence that you can get in. Some evidence is withheld as a result of hearsay or other objections like that. So of the admissible evidence, what she determined was that he was guilty of this one offense. And so, yes, I do believe he was held fully accountable.
What is your take on the supposed written admissions of guilt by General Cooley? Now, I'm referring to the apology emails that he allegedly sent to the victim and her husband, and then, later those allegedly were deleted.
Yeah. So, I mean, you can take both sides of it, right? I've been a prosecutor and a defense counsel. And so, the defense would argue that those admissions of guilt where he says, I'm sorry, and I never meant for all of this stuff to happen. I mean, I think the defense would argue that's just could also be consistent with consensual behavior and the family dynamic and all of that sort of thing. I think our position from the prosecution side was that these were admissions of guilt of wrongdoing of a criminal nature. I think probably the judge, I can't speak for her, but I think probably the judge gave that some credibility and some weight as well. Because and again, I won't say it's conjecture, but I mean, if a person has done absolutely nothing wrong, right, they're probably not going to apologize, and they're certainly not going to delete those apologies. So obviously there was some consciousness of wrongdoing. He views it undoubtedly as one way. The prosecution viewed it as another way, and the judge determined what was the legally supportable result from that.
Right. So when the judge sentenced General Cooley to a reprimand during the court-martial, what does this mean precisely? What are the career implications?
Yeah, so this is kind of unique in the military. So to maybe not unique, but certainly a part of the military. So in order to advance in the military, your record has to pretty much be spotless for an officer. A reprimand alone, even outside of the context of a court-martial, would go in an officer's permanent record and would stop their advancement through the ranks. In the context of the reprimand that he received, it's about as severe a reprimand as you can get because it was awarded in a court-martial. The reprimand itself was written by a four-star general, and as you probably know, 4 stars is as high as you can get in the military, certainly in peacetime. And it becomes a part of the record of trial, the transcript of the trial. So that has already been written, and it goes into his record of trial. And so, what are the career implications? Well, you're not entitled to retire at the highest grade that you hold at the point that you get out of the military. So when something like this goes on, as a general rule, the Secretary of the Air Force will determine what was the last grade that you served at without blemish. And so General Cooley could face getting out of the Air Force not as a general officer potentially. Now you think, well, that's not that big a deal, but if you think about the amount of money that costs over his life expectancy, it's hundreds and hundreds of thousands of dollars.
Right, and no, absolutely. What kind of new policy developments can people expect to witness in the U.S. military in regards to combating sexual abuse or violence?
Sure. Yeah, and as I'd mentioned earlier, it's the UCMJ and the military justice process in general is kind of a living, breathing thing that changes every year. Often it changes with the National Defense Authorization Act, the big body of laws that authorizes the military to do what it does and funds it and that sort of thing. And so some of the things that are coming down the road, and that some of them have already been implemented to a certain degree, are, first off, the biggest one is we're going to have an office, a special prosecution office that will be a general officer that will review these type of cases and determine whether they should go to trial or not. And that person will answer directly to the Secretary of the Air Force. So that's a fairly significant change that's coming up. Sentencing guidelines, I think are on the horizon as well as a criminalization of sexual harassment. Now I say criminalization of it. I mean, you could always get to criminalizing sexual harassment through some of the other articles of the UCMJ we had, but now we're talking about a specific article that addresses it versus some of the more generic articles. So those are the 3 things, that I'm aware of that are on the near horizon.
Right. Thank you so much. Thank you so much for speaking to us today. This was really, really helpful. And, we got a lot of information from the perspective of the Air Force as well. And I think I'm glad that, at least the victims have started speaking up now.
Great. Thank you very much, Afia. We very much appreciate the opportunity to visit with you and to be hosted on your site.
Thank you again for joining us. This means a lot. Thank you.